The RHPA model contains a number of statutory provisions and tools intended to promote public protection. Some of these ideas were innovative when first developed, for example, the Controlled Acts model. Others were built-in tools that existed prior to the RHPA, for example, title protection and complaints and discipline processes. Interestingly, although the RHPA contains a number of public protection tools and includes offense provisions that can impose significant fines on those who break the rules, up to $25,000 for a first offense and up to $50,000 for subsequent offenses, the statute does not always make it clear who's supposed to investigate and prosecute these offenses. When it is a member of a college who breaks the rules, it's clear that the relevant college should investigate, as colleges have a duty to regulate their members. However, when it's an unregulated person who breaks the rules, the responsibility for enforcement is undefined. Thus, violations of the public protection rules may go unreported and uninvestigated. Let's talk a bit about controlled acts. Controlled acts are either specific healthcare activities or classes of healthcare activities with the potential to harm patients if they're performed by unqualified people. The RHPA identifies 13 controlled acts, with a 14th not yet proclaimed as of early in 2013. These restrictions provide public protection because people are prohibited from performing controlled acts unless they are authorized to do so, or they may perform the activity using one of the alternative authority mechanisms in the Act. These include exemptions, exceptions, and delegation. Those who are authorized in statute or who are permitted to use the alternative authority mechanisms to perform controlled acts are supposed to be qualified to do so or are governed by regulatory colleges that can deal with concerns. This is intended to protect the public from those who cannot perform these activities safely and appropriately. A profession-specific act will, for some professions, grant members of the profession it regulates the authority to perform either complete controlled acts or portions of them. These authorized controlled acts are based on the scope of practice and the knowledge and skills typically associated with the members of that profession. It's worth noting that even though a profession may be granted to perform the authority to perform a controlled act, in some circumstances, the ability to actually perform the activity may be dependent on the act being ordered by a member of another profession, such as many of the acts that nurses are authorized to perform. Giving an example, injections can only be performed when a doctor orders them. This regulatory concept is intended to promote public protection by making sure that the controlled acts that are directly authorized to members of health professions only include those acts that the majority of members are able to perform safely, competently, and effectively. In addition to the direct authority to perform a controlled act contained within profession-specific acts, the RHPA also contains alternative authority mechanisms that allow people to perform controlled acts. There are 3 alternative mechanisms: exemptions, exceptions, and delegations. The rules associated with alternative mechanisms are meant to ensure the public is protected from the risks associated with performing controlled acts. Transferring authority to perform a controlled act from a health professional who has the direct authority to someone who does not is called delegation. While this process may appear to circumvent the existing rules intended to assure that only members of professions competent to perform the activity can perform it, this is not the case. This is because the rules that health profession colleges have related to delegation are intended to assure that authority is only transferred in circumstances that ensure the safety of patients. For example, both delegator and delegatee must be competent. Exceptions are very specific circumstances where the normal restrictions on performing controlled acts are lifted. These restrictions assure that activities can only be performed when the relative degree of risk is low, or when the risk to a patient associated with not performing the activity is actually higher than performing it, such as in an emergency situation. Exemptions are circumstances where certain people or controlled acts are exempted from the normal performance restrictions on the performance of these controlled acts. There are specific rules or regulations for when the activities may be performed. These rules are intended to provide public protection. The process for developing the exemption regulation is intended to ensure that controlled acts are performed by health professionals only when it is safe to do so. The harm clause is another interesting RHPA innovation. Generally speaking, public protection in the RHPA is managed by restricting the performance of controlled activities and restricting who can lay claim to protected titles. But the harm clause, Section 30 of the RHPA, provides an additional layer of public protection by prohibiting anyone, other than a health professional acting within the scope of practice of their profession, from treating or advising a patient when it's reasonably foreseeable that serious bodily harm to the patient may arise as a result. There are exceptions to the application of the harm clause, including such things as delegation, counseling, first aid, treatments that occur during educational programs, and for the treatment of family members. Essentially, what this clause does is provide another layer of public protection in the RHPA by prohibiting people from doing things that are not specifically forbidden, things that are not controlled acts, when it's likely that harm to a patient may arise nonetheless. Scopes of practice are another tool that's intended, at least in part, to help protect the public. Scopes of practice for different professions within the RHPA model are descriptive rather than restrictive. They frequently permit the activities of different professions to overlap. In this context, scopes of practice have two purposes. The first is to provide the public, the professions, and other health professionals with an indication of what each health professional generally does. Members of the public need to know what each profession does to be able to choose the appropriate professional when they're looking for health care. Members of the profession need to know what they're permitted to do so they don't extend their activities into areas of practice where they're not qualified. Members of other professions need to know what other professions can do to understand their relationship with the profession in order to work collaboratively. The second purpose of scopes of practice is to serve as a general indicator of what kinds of restricted or controlled acts members of the profession are permitted to perform, whether through direct authorization, where the authority to perform is granted in statute, or indirect authorization, where the authority to perform is granted through delegation or directive. With these purposes in mind, it's evident that while scope statements do overlap, they serve an important public protection role by making sure both professionals and the public know what a profession does. Since most colleges' professional misconduct regulations prohibit acting beyond the scope of practice of the profession, the scope statement can be used for guidance and enforcement, where a member of a profession may be performing healthcare activities that are beyond the described scope of his or her profession. This enhances public protection by allowing colleges to take action in these kinds of cases. Another important public protection tool within the RHPA and the associated profession-specific acts are the restrictions on professional titles and claims that people can make about their professional qualifications. These restrictions are of three types. There is a general restriction on the use of the title doctor in the context of offering health care, unless the user of the title is a member of one of a number of listed professions who are permitted to use this title. There are also specific restrictions on the titles associated with each profession. For example, physiotherapist. The use of variations and abbreviations of the titles are also restricted, for example, physical therapists or PT. However, except in very infrequent circumstances, the words that describe practice, for example, physiotherapy, are not protected. This sometimes does result in confusion for the public, especially in circumstances where the use of the words to describe practice are misinterpreted by the public to mean that members of a regulated profession associated with the practice words are providing the service, when this may not be the case. There are also holding out provisions in each profession-specific act. Holding out provisions are essentially prohibitions on people representing themselves as members of a regulated profession. They appear to be directed at preventing people from doing things that may lead a member of the public to think that they are members of regulated professions. While title protections are valuable tools in the ongoing attempt to ensure that people do not use titles inappropriately, they do have some problems. One such problem is the lack of clear enforcement mechanisms in the RHPA model, especially when a person may be using a title like doctor that a number of different professions are entitled to use. A second problem relates to the fact that colleges' regulatory authority does not extend to direct investigation and enforcement of the activities of people who are not their members. As a result, colleges are not always sure of their responsibilities in this enforcement area, and if they do decide to attempt enforcement, they must pursue alternative methods, such as using the courts. To protect the personal information of both the public and the profession, the RHPA in Section 36 includes strict confidentiality protections for information that becomes known to college staff, as well as council and committee members, in the course of their duties. These people must keep whatever they learn confidential, except in defined circumstances where sharing is allowed. These circumstances include, in the context of administering the RHPA and its related acts, to other professional regulators, to the police, and where disclosure is required by law. It also includes circumstances where disclosure is needed to reduce a risk of harm to somebody, or where a college believes that there's a compelling public interest to confirm that one of its members is under investigation. To encourage and promote the RHPA's quality assurance objectives, additional confidentiality protections are established in Section 83 of the Code to protect the confidentiality of quality assurance information that quality assurance committee members, staff, and assessors have. There are exceptions to this rule. If a member knowingly gives false information to the Quality Assurance Committee or to an assessor, this may be disclosed to the committee. Or if the Quality Assurance Committee comes to the conclusion that a member may have committed an act of professional misconduct, be incompetent, or be incapacitated, the member's name and the allegations may be disclosed to the Inquiries, Complaints, and Reports Committee. Confidentiality provisions are balanced with tools that permit the public to access information about college members. This includes the public register, which colleges are required to keep. And let's talk a little about that public register. The public register is the list of registered members that every college is obliged to make publicly available through its office during business hours and on its website. In addition to each member's name and business address, the public register must contain additional information, including the terms, conditions, and limitations that are in effect on member certificates, any notice of referrals to the college discipline committee, the results of any discipline or incapacity hearings that relate to the member, except where there are defined circumstances that do not permit that. Where a discipline finding is under appeal, information on the appeal must also appear until it's complete. The results of professional negligence or malpractice decisions made against the member must also be included. Also included on the Registrar are information on every revocation or suspension of the member's certificate of registration, or for professional corporations. If a member resigns and agrees not to practice again in Ontario as a result of a proceedings, a note of the resignation and the agreement must also appear on the register. Along with this mandatory information required by Section 23 of the RHPA, colleges may also require additional information to be published on the register in keeping with the requirements of their individual bylaws. The substantial amount of information available about college members is intended to promote public protection by ensuring the public has access to information that may be relevant when they are considering which healthcare provider to choose. Now I'll touch on sexual abuse protection. This is a critical public protection tool in the RHPA that relates to the provisions that protect patients from sexual abuse by health professionals. The code operates under what may be termed a zero-tolerance perspective. It includes a specific definition of what constitutes sexual abuse to clarify exactly what activities are forbidden. The sections of the code involving discipline include a number of specific provisions related to sexual abuse. These include the protection of the identity of witnesses in sexual abuse cases, a statutory definition of sexual abuse as a specific form of professional misconduct, the establishment of a program to provide funding for therapy and counseling for patients who are abused by members of professions, a penalty requirement for those found guilty to have sexually abused a patient that they have to pay for the funding for therapy and counseling for the abused person, a set of strict mandatory penalties for members who are found to have sexually abused a patient. These include mandatory revocation. Since these penalties are mandatory, discipline committees have no discretion in applying these penalties. A mandatory reporting requirement that requires members to file a report if they've obtained information while they're practicing the profession that another regulated health professional has sexually abused a patient. These provisions, among the strictest in the world when they were introduced, are intended to provide a clear message that the sexual abuse of patients will not be tolerated. In addition to the mandatory sexual abuse reporting provisions, the RHPA also includes a number of other mandatory reporting obligations. These include a requirement for people operating facilities to report members to their respective colleges when they are incompetent, incapacitated, or if they have sexually abused a patient. people who terminate the employment or revoke or suspend the privileges of a member, or who dissolve a partnership or association with a member due to professional misconduct, incompetence, or incapacity, must also report these changes to the member's respective college. Members must also self-report to their college if they've been found guilty of professional negligence or malpractice. Members must self-report to their college if they've been found guilty of an offense. The term offense means that this reporting obligation is very broad, as generally speaking, nearly every violation of law, from getting a parking ticket to committing a murder, are described in law as offenses. While these reporting obligations do provide colleges with information on their members' activities, assuring that these reports are made is a more difficult proposition. Let's take some time to go through what we've just covered. True or false? Controlled acts are healthcare activities that are potentially harmful if performed by unqualified people. It's true. Controlled acts are any of a number of healthcare activities that are restricted due to their potential to cause harm to patients if performed by unqualified persons. Which of the following apply? Authorized controlled acts are controlled acts that members of some health professions are authorized to perform, must be performed within the scope of practice of a profession, may be delegated to another person in certain circumstances, all of the above. The correct answer is all of the above. Authorized controlled acts that members of some health professions are authorized to perform must be performed within the scope of practice of a profession and may be delegated to another person in certain circumstances. The RHPA requires regulated health professionals to make mandatory reports in which of the following circumstances? A mandatory report is required if a member has obtained information while practicing that another regulated health professional has sexually abused a patient, if a member has been found guilty of professional negligence or malpractice, if a member has been found guilty of an offense, or all of the above. The correct answer is all of the above. If in doubt, contact your college for more information.